And so we have is basically four areas of intellectual property. Patents that basically cover products and processes. So things that you're going to build and then sell as units, tangible things, those kinds of products then can be covered by a patent. And then the process by which you build things. And all of this stuff should be so-called useful articles, things that are useful in the sense of helping with, health, shelter, transportation, all kinds of utility-based things like that. That's the subject area of patents. And getting a patent, as Joshua will go through, requires a good bit of time and expense. So it's not something you take on lightly, but yet it has a very strong impact on your ability to get investment, angel and venture capital funding to come in and support you through the R&D and commercialization process. Next up is copyright. And copyright covers most of the creative industries, although some notable things like fashion don't really get protection by copyright, at least not directly for the purely aesthetic elements of it, which may be a surprise to some. But a lot of the core areas of creative expression, like again, movies, TV shows, music, books, are all covered by copyright. But what's covered is the exact expression, nothing functional about the expression. It has to really be the exact expression, and then anyone who tries to copy that too closely can be then an infringer. The third area is trademarks. And trademarks are quite different in that what their role is to signify the source, meaning where a product comes from or a service. Now, interestingly, it doesn't have to actually show who that source is, but you have to have confidence as the consumer that when that mark is on something, that then it comes from the source that you bought that thing from before. And trademarks is quite broad in that it's not just particular images or names. It can also be sounds, colors, even smells. We'll go through more of that later on. But again, trademarks play a critical role in helping consumers have confidence that they're getting a product from the same source that they bought that product from a month ago or a year ago. And then finally, trade secrets. And trade secrets is interesting because it's not something that you register with any federal or state agency. So patents, as I mentioned, you have to go through a lengthy examination process. Copyright, you register, and it's not as intense of a process, but you still are registering with the Copyright Office. Trademarks, you can go with just common law rights that I'll talk about later, but you can also try to get federal registration, or many states have state registration. So all three of those, patents, copyright, and trademarks, have a kind of registration component to it. Trade secrets does not. And so basically, as I often tell my students, you act like you have a trade secret, and then hopefully a court will agree later on when you try to enforce it that you took adequate steps to then protect something of commercial value that was not publicly disclosed.